Marc Elias. I wanted to run through very quickly the events of the day, starting with the Canvas Board hearing, and then talk a bit about the efforts by the by the Coleman campaign to shut down the counting of lawful ballots. We obviously today had a good day before the canvassing board. It was a good day for the Franken campaign. It was a good day for all the voters of Minnesota who were concerned that their lawful ballots may not be counted. The canvassing board did two things of significance today. First, they ruled that the 133 ballots that were lost by the city of Minneapolis will be counted. They will revert back to the pre-recount results. And that is obviously good news for those 133 individuals whose ballots were in the envelope marked 1 of 1. And we thank the canvassing board in the city of Minneapolis for the way they handled it today. It was obviously the right decision. It was a fair decision. It's obviously disappointing that the Coleman campaign opposed what seemed to be common sense to everybody and yielded a unanimous ruling by the canvassing board. The second thing the canvassing board did today was to agree again on a unanimous basis to recommend to all 87 counties that they count or reconvene their canvassing boards to consider whether or not there were rejected absentee ballots that were improperly rejected, the so-called fifth pile, and if so, to give the counties an opportunity to review those ballots, count them, and submit amended returns to the canvassing board so that the count can accurately reflect all lawful ballots by the people of Minnesota. Late this afternoon, or after that ruling, we heard from the Coleman campaign via the media that it intends to go to the Supreme Court of the state for the purposes of shutting down that count. Fritz Knock, having originally on November 26th said that the Coleman campaign would not take issue with the counting of absentee ballots that were wrongfully disqualified or overlooked, having said that he believed that such ballots comprised, quote, an extraordinarily small number, close quote, and that is what I just read to you from the Associated Press article of the 26th of November. Today, Mr. Knock and his legal team has obviously changed its perspective, presumably because it now finds out that this is not an extraordinarily small number, but rather it involves over 1,000, over 1,500 ballots. So having originally said that they would not take issue or oppose the counting of absentee ballots that were wrongly disqualified or overlooked, they have now taken the extraordinary action. And let me be clear, it is an extraordinary action to try to halt this count and re-disenfranchise these voters. Now, there's no question that the Coleman campaign is going to spin you guys like a top to tell you that they're not trying to shut down the count and that they're trying to do something else. But just read the papers that they file when they file them, and don't look past what they file. They are seeking an injunction. They are seeking to stop counties from counting lawful ballots, and it's nothing more complicated than that. Their argument that there is no uniform standard or that they're simply seeking advice on uniform standards is cynical, and it is desperate. And it reminds me of the old phrase that desperate times call for desperate measures. I think it is fair to say that as we now approach the canvassing board hearing itself, they have, despite all of their posturing, internally realized that, in fact, Al Franken is leading by 4 votes. Which is something that we have said publicly for some time, that we are on the winning end of more meritorious challenges, something we have said for some time, and we are now in the process of ensuring that every lawful vote is counted, something which we have argued for, and they have resisted through this entire recount. So I think that times are desperate over in the Coleman headquarters, and what you are seeing today is a desperate measure to try to prevent the piece of this that they think they can prevent, which is the counting of these improperly rejected absentee ballots. So with that, I'll take any questions.
Hey, Marc, it's Marc Elias from NPR. I've been around with the Coleman campaign on exactly what they're petitioning, and some people have been reporting that they have asked that the counting be stopped until these uniform standards that they're calling for are in place. They were very clear with me after going back and forth that what they're asking the court exclusively is to set up some standardized kind of sorting and counting procedures and to do it as soon as possible. Separately, they're just asking the counties to hold off until that happens.
Okay, well,
go ahead. What do you make of that?
Yeah, well, I make of it the same thing I said before. There is a uniform counting standard in Minnesota. It is the election code of Minnesota. Minnesota's election code sets forth a uniform counting standard. It is the same counting standard that the state of Minnesota and the counties use on election day, which is there are 4 legitimate reasons for rejecting an absentee ballot. And if it does not meet one of those 4 legitimate reasons, then the vote is to be counted. I mean, imagine you are a county on election night. Okay, let's forget about the recount. Go back to election night. And you have 1,000 ballots, absentee ballots in front of you. And the reporter walks in and says, you have a uniform counting standard for how you're going to count these 4 ballots. The right answer is not, well, geez, I guess we don't. I guess we have to go to the Supreme Court and have them give us one. Your answer would be, well, of course we do. If the ballot is not disqualified for one of 4 reasons, we open it and we count it. And that was the uniform standard that was applied on election night, and that is the uniform standard that will be applied now with regard to the ballots that all acknowledge, even the Coleman campaign seems to begrudgingly acknowledge now, were improperly rejected. So there is a uniform counting standard. This is all just smoke and mirrors. They are hoping to run out the clock, delay the counting of these ballots. They have done everything that they possibly can do to keep these ballots from being counted. I mean, they have argued 9 ways till Sunday not to count these ballots. And today, I think it dawned on them that not only are these ballots going to be counted, but the cold reality of where they stand in this count is upon them, and they are desperate to do something to keep these ballots from being counted. So I don't know what the Supreme Court of the state would say other than read the election code. There are uniform counting standards, and that's what the counties ought to apply. And I'll add one other thing and then take other questions. The Secretary of State's office, quite to the contrary of the suggestion that the Coleman campaign has made, the Secretary of State's office has issued a number of guidance documents to the counties about the sorting process and how these files should be sorted. You all have had access to that, no doubt, through data practice requests. So the idea that the Secretary of State's office has not facilitated counties understanding on a uniform basis what the state law requires is not just untrue, it's patently untrue, and it is terribly unfair to the Secretary of State and the hardworking people who work there.
Mark, this is Jim with the update.
Hey, whoa. One at a time. Go Rachel first.
Thanks, Andy.
Got it, Rachel.
You had said that this is a desperate tactic, but nevertheless, won't it work? Won't this be put on hold until the Supreme Court decides whether or not to accept this case?
I don't believe it will. I don't don't see there is any reason why a county would forego making sure that its citizens have their vote counted in order to allow Norm Coleman's legal team to an opportunity to further disenfranchise those voters. If I were a county executive and I knew that there were lawful votes in my county that hadn't been counted due to error on the part of the election administration and election officials, there's nothing that Fritz Knock or any other lawyer from the Coleman campaign could write to me that would make me keep those people disenfranchised a moment longer. I think the court is going to see through this for what it is.
I've talked to several of the folks who had previously not sorted their rejected absentee ballots, and those counties have decided to wait, given that they have yet to get the direction from the canvassing board. They've gotten something from the Coleman campaign. They assume they're going to get something from you. At least the ones that I've talked to have said it's not clear that we should sort these and count these.
Well, I mean, I don't want to disagree with you because you've spoken to these folks and I haven't, but I will tell you that at each stage of this process, I have said that we have confidence that we're going to let this process play out, that we have confidence that these ballots are going to be counted, and at each stage, the Coleman campaign has told you, Here are 5 reasons why it can't happen, it won't happen. Remember, it all started with the Cannabis Board Authority doesn't even have the jurisdiction or the authority to do anything. Well, now that's gone, and now we're into uniform counting standards. So I continue to be optimistic and confident that the people who are in these counties, who oversee these elections, will want to do the right thing, make sure that their citizenry are not disenfranchised, and I think you're going to see this process move forward, and I don't think there's any desperate measure left in the Coleman legal bag of tricks to stop that from happening.
Is there another question?
Yeah, Mark, this is Noah Kuhn with the Uptake. In a letter to State Cannabis Board, Petition cites a case in Scott County where they placed no absentee ballots in Pile 5, the improperly rejected pile, even though some were rejected for lack of only the city in the witness address line. So I know you might not have the specific case here, but given this scenario, if this happened anywhere else, should those ballots be placed in Pile 5?
I'll be honest with you.
That doesn't fit under the full read.
I'll be honest with you. I don't have the letter in front of me. I don't know the specifics of what the situation is in that county or what these ballots are. I will point out, though, one other thing which gives me great confidence, which is that what you saw was a canvassing board that consisted of 1 Democrat, 2 independent judges, and 2 Republican justices of the state Supreme Court. And I don't believe that collection of judges were going to take an action that was somehow violative of the law. There was a unanimous vote today, without dissent, from either of the justices or either of the 2 judges regarding the appropriateness of this action. That vote took place in the presence of the chief law enforcement official of the state. The Attorney General sat there, opined that this was an appropriate way to proceed. So the Coleman campaign is fighting an uphill battle. You had the Chief Justice of the Supreme Court, you had another Justice of the Supreme Court, 2 district court judges, all voting for it, while the Chief Law Enforcement Officer of the state, the Attorney General, sat there and said it was a good idea. So, I'm sure Coleman has a number of high-priced lawyers who are going to try and figure out how to get this done. But as I said, desperate times call for desperate measures.
Mark, it's Josh Kraushar from Politico. I was looking at these ballots, these fifth pile ballots from each of the counties, and it seems like there's a little bit of a discrepancy when you look at some big counties like Scott County in the 2nd District. You see not a single ballot was in that fifth pile, while smaller counties have a much larger number listed on the tally. Are you concerned at all that there's discrepancies and it seems like there's an ununiform standard between how officials are counting these fifth pile ballots?
Well, I go back to what I said at the beginning. There is a uniform standard, which is that on election night they have to make a determination whether or not a ballot meets one of 4 disqualifying factors or not. And what we've learned is that in some number of instances, some number of counties, had a harder time achieving that than other counties. So, does it surprise me that some counties had fewer errors? No, you would expect that some counties would have fewer errors than other counties. I'm not familiar, again, with the specifics of any one county versus another county, but if there is a problem of lack of uniform election standards, it is that right now you have individuals who cast lawful ballots, did everything correct, and due to the acknowledged error of the county, failed to have their ballot counted. Well, how is that a uniform counting standard? How is it that my ballot counts because they didn't make a mistake, and your ballot doesn't count in the same county or in a neighboring county because they did make a mistake? So what the canvassing board did on a unanimous basis, again, 1 Democratic Secretary of State, 2 independent judges, 2 Republican justices, including the Chief Justice of the Supreme Court, what they tried to do is say, look, let's try and create uniformity. Let's try and create a situation in which counties are making sure that no one is being disenfranchised due to error. I think it's a perfectly sensible and non-controversial decision, and it is one that ought to be embraced by both sides. But then again, as I have said before, the Coleman campaign continues to go to court time after time after time to prevent votes from being counted. So it's not a great surprise they're back again.
Are there any other questions?
Mark, it's Mark. I'm Shaq with Minnesota Public Radio. Hey, there's been at least one county auditor / treasurer who said, you know what, I'm not going to be going through this and counting these ballots. It's It's not the role of the state canvassing board to tell us this. That's the role of the election contest. What's your advice to folks as they weigh this? Because some have said this earlier in the week that they're not going to do this. It should be a part of a contest.
Yeah, again, I'm going to give you the same answer that I gave Rachel when she asked this question. At every stage in this process, I have gotten questions. Well, isn't it true that so-and-so says they don't have the jurisdiction, or so-and-so says they're not going to, or so-and-so says it's impossible, or the Coleman campaign says it'll never happen. And at each stage I've said I have confidence in this process, and I have confidence that these county officials have an affirmative interest to make sure that their citizenry are not disenfranchised. I know if I were a county auditor, I'd wake up and say, well, of course I'd wake up tomorrow and I'd say, well, of course I want an opportunity for all the citizens of my county to have their votes counted. Boy, if there was someone in my county who was disenfranchised by administrative error or some other oversight, I'd feel terrible about it. I'd want to do something to correct it. And I'd point to Atascocita County, who, when it was brought to their attention that there was a mess up, to use their words, on a ballot, they did the right thing. They reacted the way you would react, the way I would react, the way any sensible person would say, well, geez, we want to correct that. We want to make sure every vote that was lawfully cast is counted. So my belief is that this process is going to work, that the canvassing board today took a very important step, a profoundly important step, in affirming that there is a problem. And Secretary Ritchie pointing out that there are 1,600 ballots that were in this improperly rejected category was a profoundly important step. And I think that the counties are going to digest this, and I predict that they're going to go through the paces, and they're going to want to make sure that the citizens of their jurisdiction have their voices heard in this election.
Take one more question.
Hello?
Yeah.
Hey, this is Eric Kleefeld with CPM. How's it going?
Doing well.
Yeah, anyway, I got a question for you. Do you expect that any of the various fifth piles that exist throughout the state right now could be counted by the end of the day?
By the end of the day today?
Yes.
I have no idea. I leave it to the counties. The state canvassing board was clear that this is something that the counties are going to be entrusted to do, and I don't know whether there are any counties counting today or counting tomorrow. I don't know what their schedule is, but we're confident that that's going to move forward, and we're going to take it from there.
One more question. Chris Steller, Minnesota Independent. What did you make of Justice Anderson's comment that he thought there would be sub-piles within pile 5?
I think that I make two things of it. Number one, I think that as oftentimes happens at these hearings where they're public hearings, right? Judges oftentimes they do their deliberations where it's not a public hearing. Often in public hearings where you're having a frank discussion, and you heard this today, not just from Justice Anderson but from others, they're thinking aloud, and they're thinking aloud as they're bouncing ideas off of each other, and that's the beauty of open meetings, that we, the public, get to see it. So I think some of what you saw on his part and the others, and I don't want to characterize specifically what he had in mind, but were four judges and justices working it out with the Secretary of State and with the helpful input of the Attorney General, who was very constructive and very helpful to this process today. I think working through how best to proceed to make sure these votes get counted. The only thing I would add is that, obviously there are a number of reasons why someone's ballot is improperly rejected. So it's possible that that's what he was referring to. In Atascocita County, they code something that the county, quote, messed up. In another place, they code it as, quote, election judge error. So, there are undoubtedly a number of reasons why an error takes place and someone's ballot isn't counted when it should be. What we know, though, is that there's a uniform counting standard, which is that there are 4 reasons in the statute, plain as day. The Secretary of State has helped to explain this to all the counties in a series of emails. And if a ballot doesn't fail for one of those 4 reasons, it is to be counted. So I think that tells you about as much as you need to know. Other than, again, I point out that Justice Anderson voted with the unanimous opinion of his colleague on the state Supreme Court, 2 judges from the District Court, and the Secretary of State, that this was the right way to proceed.
All right, thanks everybody. We got to go.